guys, welcome to my channel. My name is Debbie. We are watching the pregnant mistress murder trial, Florida v. Jose Soto-Escalera. Hey, my friends. Good morning, Judy, Jennifer, Carla, Nichelle, Marty. Wiggles is here somewhere. Aren't you? No. Where are you? She'll find her way over here. Carla. My redirect didn't work? So once again, we are pausing trivia. You guys are talking about Judge Oakley. My redirect didn't work. I'm sorry. Yes, Judy gives us trivia on the cases every day. And today we're not doing trivia because instead we are remembering the slain policeman in York County, Pennsylvania this morning. Oh, that's cool, Nichelle. I know my cousin has, she used to teach at a private school, and they would do field trips at, what's it called? Kennedy Space Center? Is that what it's called? Here in Florida? NASA, whatever it's called. I've never been. I want to go. I just have never been. And they used to sleep underneath the exhibits, like underneath the rockets and spaceships and stuff. Why are you going to be lurking, Wiggles? You going to pretend to do some work today? Hey, Terry. Okay, I think they are still arguing about that stupid tape. I just caught a little snippet of it. I don't know why. Oh, it's your day off. Okay. Well, then that's different. Go have fun. Come on, StreamYard, share my screen. What the heck? Now what is happening? What are you doing? I see that StreamYard's not responding. Am I back? Hey, Tricia. Okay, that was weird.
Before we get started with the evidence.
That was weird. Everything just locked up and wouldn't let me do anything. I don't know what that was about. I'm so tired of YouTube changing stuff. Why did you change the way you maximize? Thank little X so I can get out of that.
Jurors are all in the back, I'm told, all of our jurors? Okay. Any issues to address before we get started with the evidence? From the state? Any issues to address before we get started with the jury? No? Y'all ready for the jury? Yes, sir. All right, let's bring the jury. We'll get started. Okay. Okay. We'll go to the record for them to come in.
I bet that's what's happened. That is going to be what it is.
All right. Good morning once again, ladies and gentlemen of the jury. As you're aware, it's my custom at the beginning of every court session to re-advise you the most important principle of a fair trial is that you, the jury, judge the case only on official evidence presented to court and nothing else. Continue not talking to people involved in the case with anyone, including your fellow jurors. Don't do any research in any form whatsoever, and avoid all media coverage of the case in any form whatsoever. We continue with the state's case, and the state may call its next witness.
We call Elizabeth Bedola.
Please swear or affirm that the evidence you're about to give will be the truth, and nothing but the truth.
Why are they recalling her mom?
And you may have the witness.
Good morning.
Good morning.
If you could just state your full name and spell your last name.
It's Elizabeth Bedolla, Bedolla.
Okay, and you are Tanya's mother, correct?
That's correct.
I want to show you what's been marked for identification. State's Exhibit 146. Do you recognize this?
Yes.
How do you recognize that photograph?
She's my daughter.
Okay, and is that your daughter from when she was alive?
Yeah.
This time of state, we're moving to evidence what's been marked for identification as State's Exhibit 146.
No objection.
That item will come into evidence without objection.
This time of state, we'll just publish what is marked or entered now as State's Exhibit 146. Thank you, ma'am. I don't have any other questions.
Any questions from the defense?
No, Your Honor.
Thank you. You may step down. And the state's next witness or item of evidence.
That was weird.
Yes, sir. People say before I call Rose Rosario.
Why didn't they do that the first time they had her on the stand?
If you can raise your right hand, okay, so clerk.
You swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth, please? Thank you.
Or that way to witness.
And you may inquire of the witness.
Morning.
Good morning.
Can you state your name for the record and spell your last name, please?
Yes, Rose Rosario, Rosario.
Okay. And Ms. Rosario, what do you do for a living?
I am a interpreter, translator, transcriber, practitioner.
Okay. Go ahead and give the jury a thumbnail sketch of your education, your training, and your experience, please.
Yes, good morning. I was trained by the Uruguayan Air Force. I was a diplomat interpreter, translator, and later I started working in 2004 with homicide units for the 19th Circuit Court, and then with the 17th Circuit Court, doing transcriptions and translation.
And where is the 17th Circuit?
17th Circuit is in Broward,
Broward County?
the Broward courts, yes.
Okay. I didn't mean to cut you off. Go ahead.
No, no problem. I got my certification in 2012 as a transcriber, translator, practitioner. And I've been working the field close to 21 years.
Okay. And just some background questions. Where did you grow up?
I grew up, I was born in Cuba. I came when I was in the second grade, so I was raised in Hialeah, Miami area.
Okay. And were you raised in a home where Spanish was the primary language?
Yes.
Okay.
Yes, it was.
And did you learn English? Obviously, you know English, right?
Mm-hmm.
Okay. And how well do you know Spanish? It's obvious, but how well do you know Spanish?
Oh, very well. My parents made sure that the Spanish language was not lost when we started school. So we had to take Spanish lessons all the way from elementary to high school.
Okay. And did your parents, did they only speak Spanish, or were they able to learn English as well?
No, they learned English. They were nurses, so they learned English.
Okay, good. And did you have any formal education in Spanish?
No, not formally, just the one that you take in school, advanced Spanish. And Spanish was always spoken in the at home.
Okay.
And then I married into a Spanish home also.
Okay. And you said that you worked for the Uruguayan Air Force?
Yes.
Okay, go ahead and describe that experience for the jury.
Okay, I worked as a diplomat, interpreter, translator, and transcriber.
Are you
So,
having difficulty hearing the witness? If you could keep your voice up. And
oh,
move-
I'm sorry. Okay, at the Uruguayan Air Force, I was trained as a diplomat, interpreter. I was the interpreter for the assistant air attaché. So we did all the interpreting for all the foreigners, vendors that came into the office. I translated everything that was done in that office was received in Spanish and had to be translated into English. And then with the vendors, it had to be translated back from the English into the Spanish to give back the responses to the Uruguayan Air Force. It was your purchasing office.
Okay. And you did that for how many years?
5 years.
40 hours a week?
Yes.
Okay. And from that point forward, where did you go and what did you do as it relates to to Spanish and Spanish translation and interpretation?
I started, let's see, in 2004. I went back, I got away from the interpreting field for a little bit. I did real estate. Then in 2004, I got back again into the interpreting field. And I started working with 19th Circuit Court, doing the transcribing for jail calls, confessions, everything pertaining to homicide cases.
Okay, and go ahead and you mentioned that you had obtained a certification.
Yes.
Can you explain that to the jury, please?
Yes, in 2012, I got a professional certification for the transcribing, it's called transcribing translator practitioner. And by that time, I already had acquired about 5,000 hours of transcribing and translating for the Uruguayan Air Force. From 2008 to the present, I've acquired 4,500 hours in homicide cases for translating and transcribing.
Okay, and to be clear, the primary language of Uruguay is Spanish.
Yes.
Okay, and describe the transcription process for the jury. Tell the jury about that.
Okay. First, we get the sound file or the audio files. We listen to it. You have to listen to it several times before you start transcribing so that you can get familiar with the voice, the speech pattern, the volume. Once you hear it a couple of times, then you start the transcribing process. The transcribing process is done before you start the translating part. Once you have that, if you take a look at the format, you have a column that's in Spanish and a column that's in English. So once all the transcription is done, it gets proofed. We proof it to make sure that we've got everything down that was transcribed. After that portion is done, then we start with the translating part.
Okay, and let me ask you this. Is there a difference between translation on one hand versus interpretation on the other?
Yes.
Okay.
Yes.
Explain that distinction to the jury,
Okay.
please.
So the interpreters interpret orally. The translators, we do documentation, word documentation. Everything that's in the written form, it's a translator. Versus the interpreter, which does oral.
Okay, so as a practical matter, is there a big distinction between the two? Describe the distinction in practical terms to the jury.
Yes, there's a big distinction. It's two different professions. Sometimes there are translators that also do interpreting, and the same way interpreters that do translator, but it's a different field. Interpreters go in and out. They interpret on the fly. Translators have more time to work with the document. We're able to research and go over again the document or the file that we're working with.
So let's say I were to call a witness who only spoke Spanish. Would you be the person to interpret that to the jury, or would you not do that?
No, that would be an interpreter.
Okay, so to be clear, what you're doing is translation, you're not doing interpreting.
Correct.
Okay, thank you. Okay, and were you provided some evidence in this case, the state of Florida versus Jose Soto-Escalera?
We were provided with sound files and videos.
So I'm going to show you what has been marked as State's Exhibit number 169. Do you recognize this?
Yes.
Okay, what is that?
This is the denoised audio video, about 11 hours long.
Okay.
That we worked on.
Is that an external hard drive that contains the audio and video and all materials you reviewed
Yes.
in order to arrive at your conclusion in this case?
Yes.
Okay, and did you translate the August 24th, 2018 video and audio from a Waste Pro garbage truck?
Yes.
Is that what's on there?
Yes.
Okay, and did you reduce your findings to a written transcript?
Yes.
Okay, and does that transcript reflect what you listened to when you listened to exhibit number 169?
Yes.
Okay. And Your Honor, permission to publish using the same procedure we did yesterday?
You can ask the witness questions about content of sections of the item.
He's referring to having another person come in to read.
Oh, okay,
Yeah.
yeah, but in that form, yes, you
Yeah,
may do that.
okay.
Okay.
Okay. We're going to get Mr. Blanc. And while we're doing that, tell the jury how many hours that you spent on exhibit number 169 in arriving at your conclusions.
Okay. Like I said, it was an 11-hour video. We spent close to 110 hours, between 110 to 150 hours working on the videos.
Okay, okay. Over a period of how many weeks or months?
About 2 months, 2 to 3 months. Because the way you do this, you can't work on these more than 5 hours. It's too exhausting, so we do sessions of 4 to 5 hours tops.
Okay. And, okay. Ms. Blanc? Come on.
Do you have a copy of your transcript? You can use it. Morning, Your Honor. Morning.
Okay, here we go again, guys.
Okay, so, Ms. Rosario, can you, we'll start off on page 1, and Mr. Belanca will play the role of the individual that can be more audible. Ms. Rosario, you will play the role of the individual that is less audible. Does that make sense? As we described in my office?
Yes.
Okay, okay, so we'll go ahead and start on page 1. Ms. Rosario.
Know what's crazy? All these gloves are,
Throw all that out.
it's garbage.
Audible.
Where the hell is the ox tape at?
That's in the bag. Oh, Lord, I'm tired.
Can't stop thinking about that. I have provided a lot.
Huh?
Things that are running in my head.
Why?
Can't think about it later. That I would have. Unintelligible.
Well?
You can't be mad at people.
Huh?
You can't be mad at the people.
Yep.
We can throw it in there.
Put on the gloves.
Okay.
Objection, Judge, may we affirm?
Yes. Let me refer to,
You follow me, Ms. Rosario?
Yes.
Okay, go ahead and read all of that particular section, please.
Okay. We can throw it in there. Put on the gloves. Okay. The ones of that black.
What's going on? I don't understand what's happening.
okay,
Line 20, Mr. Blanca. Yeah.
We can throw it in there. Put on the gloves.
The ones of that black?
Yeah, stay with those. Don't let, because they have my prints. Pretend that so that nobody sees you. Sure, it's good. Right here, bro.
Just open the door.
We can throw it out in the España.
Almost there, inaudible.
Can back up. You know, we'll do it inside, man. It's best. It would be good with trash. If it don't work out, okay.
Back and forth through there. It's coming.
Take it out of the bag, put on the gloves. Take it out that I'm going to inaudible. Sure, it's right here.
Who's gonna find a gun there, bro?
I don't know, bro.
Yeah, ain't nothing outside.
That was incorrect. We need to go back. As far as who speaks the line, correct? Sure.
That I was wondering about that too.
Jury, let me ask you to step back into the jury room for a moment so we can sort this out. We'll be with you momentarily.
Okay, I was right. I did hear it. They are.
Please leave your notes in your chairs and do not discuss the case.
Oh, they're talking about the gun. Yeah, I thought they were talking about Tanya too. What's the deal with the gun? Because she wasn't shot.
All right, we'll go off the record as the transcript is being highlighted to avoid the wrong parts being spoken. Go off the record momentarily. And that will be stated by whoever's going to state that.
Right.
You're still doing the highlighting? Okay, take your time. I'm going to instruct them on that.
No, yeah,
That's
but
what I mean.
we didn't
Neither
tell them
transcript is
Yeah.
going to go back,
Right.
not just this one.
Right,
Yeah.
okay. Still doing the highlighting. Okay.
Thanks, Trish.
This is ridiculous. Why are they waiting
Give me 1 second.
till now to do this? They've had 7 years.
All right, back on the jury is not present. All right, back on the record, jury is not present. There was another issue.
Yeah.
Stay.
If you'll take a look at page 3, and it's line 37. Let me know when you're there. Ms. Rosario, can you please explain, if you take a look at page 3, line 37?
Okay, so, on page 3, the box 37, they stepped out of the truck so we were not able to see who was the person speaking. I just transcribed the conversation as I heard it without designating anyone because I wasn't able to see who was doing the talk.
From the reading, as we cannot attribute it to what we're now calling the closer participant and the further away participant.
No objection.
All right, so you're both agreeing just not to read that?
Correct. Yes, sir.
Entry 37, okay, that's fine. Otherwise ready for the jury? They're still doing the highlighting?
Yep,
Okay.
lots of boxes here, sorry.
To be clear for the record.
There's another one that was the third
Right,
person.
37.
Seven. And that was the third person, okay, so that's what,
No, sorry, Judge, just to be,
that was the third person, okay, so that's what,
no, sorry, Judge, just to be clear for the record.
there's another one that was the third
Right,
person.
37 is allegedly, this witness is saying that in 37, the two individuals stepped out of the garbage truck and they cannot determine
Correct.
who the speaker is.
Just off the record, Mr. Richardson said no one's reading MV3, and that's not accurate. The state's gonna read MV3
I'm gonna read
on the other
MV3 on
page.
page
Okay.
Yeah,
Correct.
I thought you were talking about the one that we
37.
did.
No one's reading
No,
37.
usually-
Correct.
Yeah.
I'll go off the record momentarily.
What? There's nothing up there. There's nothing up there. There's not anything up there. What? You come up here, you gaslight me, you look at the ceiling and meow. There's nothing up there. And now you're staring at me like you want me to do something about it. There's nothing up there.
All right, ladies and gentlemen of the jury, in the witness and the conduit witness, as I refer to it, reading the evidence, there was some slight mishaps, which is going to cause us to go back to the beginning. You should know the testimony in this regard is going to be much shorter than the one you experienced previously. Also, I wanted to tell you before we get started, too, as I mentioned, it's up to you to decide whether or not to take notes.
Yeah,
But
what
in
did you
making your
do?
decision I think you should know this information. With regard to the translation evidence, which is what we're doing here, the evidence is what is being said in court here. The transcripts themselves that the witnesses are using to do that are not evidence pursuant to law and will not be available to you during deliberations. So please be aware of that. You should know, though, too, during deliberations, should you need to, you do have the ability to re-listen to the testimony, to be brought back into the courtroom, and I would replay the testimony to you. You would have to hear the testimony in its entirety unless we were to determine otherwise, but that is the default legal position. So I just tell you that in your decision whether to take notes. And as I mentioned before, disregard what you heard previously because it's going to go back and restart the testimony in that regard. And you may do so, Mr. Richardson.
Yes, sir, thank you. And Mr. Sorry, before we begin, are parts of this also in English that the speakers are using? Are they using a mixture of Spanish and English, or is it completely Spanish?
Sometimes it's in Spanish, sometimes they use what we call Spanglish, which is a word that it's anglicized, or they switch code, which is they speak in a sentence in English and Spanish.
Okay, and a few more questions. Are you familiar with Spanish that's like variations of Spanish, like Puerto Rican?
Yes.
Okay, explain briefly to the jury your experience with Spanish derived from Puerto Rico.
Okay. Although I was raised in a Cuban family, my husband, whom I was married to for 25 years, is Puerto Rican.
Okay. Do you have any trouble or difficulty understanding Puerto Rican?
No.
Or Puerto Rican Spanish?
No,
Okay.
the regionalisms, no.
Okay, all right, so now we're gonna start again, and we're gonna start on page 1.
Mm-hmm.
And we're gonna start with line,
Before we do that, can you explain the other part where Mr. Cormier is going to be assisting what's going on there?
yes, Ms. Rosario, is it your understanding that Mr. Corm, is there a third participant within this particular item of evidence?
Yes.
Okay, explain that to the jury.
Yes, there's a third participant, which is when they get to the weight station, and the guy that's doing the weights, the scales and all.
Very brief explanation of why someone else is speaking.
Okay.
Without,
Without getting into what you saw and what you heard, just why is there a third party there?
Because they get to the weight station and,
just as far as the voice is heard and why there's a third speaker, just focus on that, not with regard to what's going on in the context.
we designate a voice number for everyone, for every speaker that we hear. So number 3 would be that person.
Number 3, again, is an unknown party.
Correct.
Okay, gotcha. Okay, so we'll go ahead and start.
Okay. Know what's crazy? All these gloves are inaudible.
Throw all that out.
It's garbage.
Inaudible.
Inaudible. Where the hell is the aux tape at?
That's in the bag. Oh Lord, I'm tired.
Can't stop thinking about that. I have provided a lot.
Huh?
Things that are running in my head.
Why?
Can't think about it later. That I should have, I would have. Inaudible.
Well,
You can't be mad at people.
huh?
You can't be mad at people.
Yep. We can throw it in there. Put on the gloves.
The ones of that
Yeah.
black?
Yeah, stay with those. Don't let, because they have my prints. I'll pretend that nobody so that nobody sees you. Sure, it's good right here, bro.
Just open the door.
We can throw it out in the España.
Inaudible. Almost there. Inaudible.
Can back up? You know, we'll do it inside, man. It's best. It would be good in with trash. If it don't work out, okay.
Back and forth. Back and forth. Through there. It's coming.
Take it out of the bag, put on the gloves. Take it out that I am going to inaudible. Sure, it's right here.
Who's gonna find a gun there, bro?
I don't know, bro. Yeah, ain't nothing outside.
Up to there is good.
Put it on the floor then.
Huh?
Put it on the floor.
If there are many cars, forget it. Go back.
Don't look that way. I'll tell you, inaudible. Ready to come inside?
Here. You don't have any messages or anything like that.
Where?
Of hers. Online.
Threatening her or something like that?
No.
No, none of that.
No. No.
There's none of that.
Inaudible. No? Inaudible.
Let me go see something. I did inaudible things. Good.
I could have done it alone.
Huh?
I could have done it.
You know why I showed my face? So that they don't assume.
Take the right. Where the hell are you going, bro?
When I get home, I have to go check it right there. You know what I need from you? Keep me occupied, so I don't think. I was talking to a policeman friend of mine about things like this. He says that it is not proof of anything. It is inaudible standard. That is not
Yeah.
like a revolver that leaves prints.
As soon as I walk in, all she looks at me and she says, inaudible. Somebody else. Inaudible. 6:45, bro. And don't call.
I left at the house 5:05 on top of the fucking pad.
Huh? Telephone call. Hello? Hey?
I have to go to the house. Got to go to my house right now. You hear me? Got to get something. Yeah.
Telephone conversation. I'm on the road. Inaudible. Can't get to. Inaudible. Oh, that's what I'm saying. I'm on the road.
Is she still at the house?
Huh?
At her house?
She's leaving. She told me she would like. Inaudible. Oh, God.
Well, I'll see you at the house because I have 4 cartridges bags on top of the pickup truck there that match the cassettes.
Where are you going to pick it up?
Now, move, dump that, go to the house. Should I tell Mike, inaudible, I'm driving and my wallet I left at home?
Can't be fucking. You can't think too much. You can't be back and forth because that's how you get caught.
That's tough.
You gotta act calmer.
Yeah, the auxiliary port cord. It's there in that bag.
Huh?
The auxiliary. I'm saying the wire.
I had it there, right there. This part here. You put it in.
Hold on a second.
Mr. Rosario, can you please restate number 72 on page 5?
Yes. I had it here, right here, this part here. You put in the output and this little thing. You just put it, I put it right there and it all stays.
It's rolled up in that little black thing. You'll see it. It's in the top zipper. Where are you at? You're in the wrong place. There, right there. Should be wrapped up in a little black inaudible.
Inaudible.
I'll do it. Tell me what it is saying.
Welcome, right there. Inaudible, right there, inaudible. Main road,
Already dropped the kids off?
inaudible. Did she have any money yesterday?
Huh?
She didn't have any money on her?
I didn't have time for that.
She didn't have money?
I don't know. Why?
Was asking. I should have went.
I I think it,
Man, they're killing their beat, bro.
why?
They went through his road.
No, he didn't.
Yes, he did. Inaudible.
Who's the driver?
Johnny.
That means he's in there then, right?
Oh shit. That's a Waze Pro truck.
Yeah, put some like Aventura, like Bashada shit like that. Go on. Do you have some Romeo?
Huh?
Romeo Santos?
Santos? What kind of bullshit is that one? Definitely dirty.
That's Inaudible Dad.
Huh?
His dad.
Where?
In that yellow Inaudible GTO.
Ah, my head keeps on hurting.
Inaudible.
Inaudible.
What time is it?
8 something. 8:16.
Let's see what the fuck he said.
Who? You wanted to go. Inaudible, right?
No, no.
Yawns out loud. Inaudible. You got one more.
Huh?
Inaudible. Up front.
Huh?
Inaudible.
I want to do it when I get out of here.
Inaudible.
Huh?
No man can be happy. Oh, that's all I need.
What?
I'm totally fucked.
Do you have water in there?
Inaudible.
Huh?
Inaudible. Something burnt?
Put something Traviano.
One's life, bro.
I need a fucking drink.
What are you going to do with this?
I have food.
You're gonna eat salad? We're here.
Get me a drink. My fucking mouth is dry.
Huh?
My mouth is dry. Did you hear me? Can you grab me a Monster or a Gatorade?
What?
Hey, inside.
You wanna inaudible?
Huh?
Ain't it?
Huh?
Inaudible.
Who?
You.
An orange one?
Inaudible.
Good.
Now you know how I feel when I get no sleep. I get dehydrated the next day.
It's hot out.
Eat this, inaudible. The dehydrate will go away.
I like when inaudible.
If you eat this, you get hydrated.
You don't want to eat it? The last one?
Good Lord, what are we talking about?
Fuck you, bro.
Nasty.
Want a sandwich? Hey, want to put your music on? Tastes good, right? Fuck that sandwich up. Rice and beans with ham?
Not yet. Why don't you turn it on? Hey, this bitch is bad enough, inaudible. Lip syncing. Like right there.
There?
Lip syncing. What happened, bro? You're falling asleep.
I'm falling asleep. I'm going to take a 30-minute break. You have to put the one of inaudible Gil. Put on the heavy music.
Lip syncing.
Do you know how I feel now? Like in a beer mode. I'm thinking crazy. I want to bank, bro. I'm inaudible if I have to. Can't do that though. Inaudible.
Can't do that too, inaudible. Because I have to be calm like that now. Everything to them. It's fine.
Did she have a purse? Hers? No. If they find her now, they can't do the inaudible final because the mom is not called. She is not missing yet on this side. They don't consider her as missing. The what did she die of? What did she have? What does she have? So they will put her in a box, take her out the sun, inaudible, problem. And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths when I got to her house, and I bathed this morning. I bathed. I cleaned my hands with the cleaner, the one for breaks because I had gloves and everything just in case.
Did you see the blood?
Huh?
Did you see blood? Did you see?
I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag.
Inaudible.
Exactly. What's for dinner tonight, bro?
Huh?
What's for dinner tonight? I'm thinking pizza. You know I can't go to that street no more.
Which, that one?
By that street.
You're confused with the streets like that.
By there no more with this truck. They can watch me also with that.
This is a work truck, man.
Huh?
This is a work truck. Inaudible.
Right. Did you make the landfill? Inaudible. Everything?
I hope so.
Inaudible. I want to move forward and get out of this mess. You got to run through this side right here. It's bigger. Inaudible.
Inaudible.
Hold that. Hold on so I don't lose it.
Lip syncing.
You said there should be one over here?
Huh? Huh?
Huh? There should be one over here?
Nothing there.
Huh?
Nothing there. Inaudible. Bro, look at her hair. Laughs out loud.
Watch there. From the back.
Inaudible.
Who?
I'm starving, man.
We'll get a little piece of food. I have to put my plate back of that. I'm going to put it there. The plate, put it back.
Of your car?
I took it off. The one that says Puerto Rico, I took it off. I have to put it back on. Do you smell that burnt shit?
Huh?
Smell it. What is that?
I don't know.
You smell it though, right?
Yeah, keep your eye on it. Can be your battery. Did it start otherwise right? Keep your eye on it. Radio still working?
Yes, sir. Thank you. He waved at us and everything.
He said it audible. Inaudible.
Huh?
Inaudible.
He waved at us. Nice and easy.
All right. What do you feel like cooking tonight?
I don't know.
All right, look.
That's probably what it is.
What?
The batteries.
Thank you. Okay, Ms. Rosario, to do one more item here. Did you, were there portions of these videos and audios that were more difficult and less difficult to hear? Were more of them audible and some of them unaudible, or what? Can you explain that to the hearer?
Yes, they were, all this was taking place in a truck, so there was a lot of noise. And he had the radio on also. It was difficult, but doable. We took a lot of time with it.
Okay. I'm going to go ahead and publish, do you have the, I'm going to go ahead and publish a part of it. And if you could translate that portion, and if you need to, refresh your recollection with the transcript. Does that make sense?
Yes.
And for the record, the portion that we're going to start on is page 10, line 167 at 5 hours, 59 minutes, and 48 seconds. Okay, Mr. Rosario, you ready?
I'm sorry, could you repeat the portion, the
So
section?
we're going to go to page 10,
Mm-hmm,
line number 167.
okay.
Okay. Now, Ms. Rosario, if you could refresh your recollection and tell the jury what was said at that portion.
On that side, on that portion, he was saying, no, if they find her now, they can't do then it was inaudible. Final, because the mom has not called, she's not missing yet. On the side, they don't consider her as missing. The what did she die of? What did she have? What does she have? So they will put her in a box, take out the son, inaudible, problem. And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths. When I got to her house and I bathed, this morning I bathed, I cleaned my hands with a cleaner, the one for breaks, because I had gloves and everything just in case. Did you see the blood? Huh? Did you see the blood? Did you see? I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag. Exactly. What's for dinner tonight, bro? Huh? What's for dinner tonight? I'm thinking pizza. I think that's what somebody.
Okay, thank you. And to be very clear, the person who said I had it all over the clothes, but without the evidence, they can't do nothing, was that the individual that was easier to hear?
Yes, that was,
The individual is easier?
yes, MV1, yes.
Okay, all right, thank you. Ms. Rosario, I appreciate your participation. I have no further questions. The defense counsel may have some for you, okay?
Cross-examination.
Thank you, Judge. Ma'am, how many times have you testified in court?
This would be about the 7th time.
7 times. How many times of those were for the defense?
I believe a couple of times.
A couple?
Yes,
How many?
2 times.
2 times. Okay. You said that you spent 110 to 150 hours working on what we just heard.
Yes.
How much do you get paid an hour?
$95 an hour.
$95 an hour. Okay. You did a certification for that transcript that you just did, the reading up,
Yes.
is that right?
Yes, yes.
Okay, and on your certification, you said pertaining to this case from 8/23/18 is a complete and correct transcript translation from Spanish to English, is that right?
Correct, yes.
Okay, so you certified that this was from 8/23/2018, correct?
Yes.
Okay, no further questions.
Any questions? Further questions from the state?
If you look at your certification, 8/23/18, is that a typographical error?
I don't have the,
I'll show you the certification. Will that refresh your recollection?
yeah, I mean, if that's what I have. Oh. 824, okay, that's a typo.
Okay. Does the video,
It's a-
go ahead and read the video, title of the video and evidence into
Yes.
the jury, please.
The title is, it-
I'll sustain the objection. I believe the item that's referred to is not in evidence, so it's asking for the witness to read something that's not in evidence.
Okay. Can you tell the jury this title is?
Objection.
Yeah. Can you- I'm going to show you the electronic copy of the file
Objection,
from
Judge, we approve.
Exhibit 169.
Let me, well, wait for a question. Let me see what the question is.
Okay.
The previous objection was sustained because the witness was being asked to say something to the jury regarding something that's not in evidence. If you're using it to refresh her memory, you need to ask a substantive question. Can assist her in answering the substantive question. She can't ask her a question to read something that's not in evidence. So going forward with that clarification, ask another question.
Yes, sir. If I were to show you an electronic copy of the file that you used in arriving at your conclusions, would that refresh your recollection as to the date of the translation, as to the date of the video that of the recording in this case?
yes, it's 824, there was just a typo where I'm referring to pertaining, but the body of the certification has the correct date,
Okay.
824.
Okay, tell the jury again, what is the correct date of the video that you
Yes,
translated?
the correct date for the video is the one I have right on the text.
Any objection? You need to answer the question without referring to a document.
Yes, the correct date is 8/24/2018.
Thank you. No further questions.
Any further cross-examination?
Just briefly, but on the thing that's called a certification, you wrote that the date was 8/23/2018, correct?
That's on the bottom part. On the main text, it has 8/24.
I'm asking on the certification itself, the thing that's called certification. You're looking at it right now. It says 8/23/2018, correct?
That's the second part.
Okay, so we didn't even get that correct, right?
We have, it is correct on the main, what I am, the title that I am certifying
Ma'am,
is
ma'am,
8/24/2018.
Permission to approach the witness, Judge?
You may.
I'm talking about the document entitled certification. This is the document.
Correct.
And that where the date is, the certifications is 8/23/2018, correct?
That is not the correct one. That is not the certification. This is a preliminary certification which was emailed because they were in a hurry.
Okay.
To show the judge. This is the final one. And it's got all the information.
Oh, so we got it wrong in the initial one and in that one, correct?
It is not, well, over here on the second part,
It says
8/23, but the text, what I am certifying is correct, August 24, 2018.
Okay, but it says 8/23/2018.
Objection.
At the
That's
bottom is a typo.
I'll sustain the objection. I think
certification
it's been
is
asked and
24.
answered at this point.
No further
Any
questions.
further questions from the state?
No, sir. Thank you.
May this witness, Ms. Rosario, be released from her subpoena at this time?
Yes, sir.
Any objection to releasing the witness?
No, Your Honor.
You may be released from your subpoena. You're free to stay or leave as you wish. Thank you. You may step down. And the state's next witness or item of evidence.
Yes, sir. People State of Florida recall Detective Chris Newman.
Raise your right hand, please, clerk.
Do you swear affirm that evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you.
And you may inquire of the witness.
Good morning, sir.
Can you state your name for the record and spell your last name?
My name is Christopher Newman. Last name is spelled Newman.
Okay. And during the course of your investigation, did you learn the location of the defendant's residence in August of 2023? Or, I'm
Yes.
sorry, August of 2018?
Yes, sir.
Okay. And what was the location of his residence? What was the street address?
I know it was on Cactus. The exact address escapes me right now.
2613 Southwest Cactus? Okay. Did the defendant live at 2613?
Objection, leaving.
I have never
suggestion.
in my
I'll overrule the
life
objection. It's an open-ended question.
heard
Did the
so many
defendant live at
objections.
2613 Southwest Cactus Circle?
Yes, sir.
Okay. And was a search warrant executed on that residence?
Yes, it was.
On what date?
Hey, Nancy.
I believe it was August 28th of 2018.
Okay. And did you recover, did anyone from the sheriff's office who executed that search warrant recover any clothes with blood on them?
No, we did not.
Did you recover any weapon with blood on it?
No, sir.
Okay. And, sir, that is all the questions I have. Thank you.
Cross-examination?
No cross.
At this time, may Detective Newman be released, or you wish for him to remain under subpoena?
I wish for, ask for a remand.
Please step down, Detective. You do remain under subpoena. And the state's next witness or item of evidence.
Premature approach?
Sure.
Nancy, you've been a member longer than that, haven't you? You just keep changing your name, right? I could have sworn you've been a member longer than that. She just cannot help
We're going to take a
herself.
restroom break at this time for 10 minutes. Please do not discuss the case with each other. Leave your notes in your chairs. We'll be with you in 10 minutes.
She likes to object to everything. This is the most objections I've ever heard in a trial. She just can't help herself.
Overlapping portions.
We're
of
not
what-
even playing it, we're just,
Okay.
we opened it, which, it's in evidence, they can view it, but I'm just making sure if there's any issues beforehand, I want to.
Which one was the 169, which translator person?
August 24th with Rosario.
With the one that
What we
was
just-
just
yeah.
testified to. So this is the video and audio portion, and you're just playing overlapping portions.
We're
of
not
what-
even playing it, we're just,
Okay.
we opened it where you can see a pic of, inside of the
Picture of
truck,
what
and you
it
can
looks
see
like.
some people, someone
Okay.
driving and someone in the
It's
passenger.
just stills,
This is a video, but it's
Okay.
paused.
okay?
After they do their identification, we're gonna take it down and then we're gonna play audio.
Yeah. And then,
Okay.
and then following that, we're gonna do the same thing with the exhibit number 170, which was testified to by.
I just want to be sure that what you're playing is what has been testified to.
Yeah.
It has, and we are not playing any portion that we agreed is redacted.
Okay,
Perfect.
Right.
yeah, okay. Very good, let's bring in the jury. All right, the jury is present, and we proceed with the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida recall Adolfo Cavelli.
Raise your right hand.
Yes, sir.
Clerk.
Do you swear affirm that evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Yes, sir.
And you may inquire of the witness.
Good morning. Can you state can you state your name for the record and spell both your first and your last name, please?
Yes, sir. Adolfo Cavelli, Adolfo, last name Cavelli, C-O-V as in Victor, E-L-L-I.
Okay. And I believe you testified a few days ago. Were you a senior official at the Waste Pro location here in Fort Pierce in August of 2023? Or, I'm sorry, August of 2018?
Yes, sir.
Okay. And were you familiar with the trash routes of the drivers in August of 2023?
Yes, sir.
Okay. Were you specifically familiar with the trash route of the defendant Jose Soto-Escalera?
2018.
Yes, sir.
Okay.
Quit saying 23.
Did he have a trash route in northern Fort Pierce?
Yes, sir.
Okay. Can you tell the jury what his trash route was?
Yeah. I can't give you the exact every road and all that, but it was in North Fort Pierce, in the Andrio Road area, Johnson Road, Rousseau Road, around the
Congrats,
Spanish Lakes area,
Nancy.
in northern Fort Pierce, St. Lucie County.
Okay. And can you walk the jury through was there a system in place where each of the employees of the Waste Pro, if they were on a garbage truck, what was their knowledge of the camera and recording system?
Yes, sir. So I was there when we had the cameras installed, and every employee that was in the vehicles had to acknowledge that they were being recorded both by audio and visual recordings.
Okay. So did every employee who was assigned to one of those garbage trucks have specific knowledge that they were recorded
Yes.
and that they were videotaped?
Yes.
Okay. And how well did you know the defendant, Jose Soto-Escalera?
He was an acquaintance and an employee, like most of the employees. I was very close with them to get to know their families and ask about them, and Jose was one of those people too.
How long do you think you knew him?
I would say backing up from 2018, a few years. I believe Jose worked for us and then left and came back, but regardless, I've known Jose since his employment at Waste Pro.
Did you have many conversations with him?
Yes.
Did you know him it sounds like you knew him in the context of work, is that correct?
Yes.
Did you also know him socially?
Yes. Yes.
Okay. Do you know him well enough to visualize him, identify him?
Yes.
Okay. We're looking here at a freeze frame of one of the videos from exhibit number 169. If you need to, step down, but do you see Jose Soto-Escalera on the smart TV?
Yes.
Okay. Can you identify him? Which one is he?
The gentleman with the glasses and the steering wheel in front of them to the right of us looking to the right.
Okay. And who is the other individual in the vehicle?
I'd like to come up with that.
Sure. Who is that?
The helper of the route, Eric Alvarado.
Okay. And did you speak to Jose Soto-Escalera enough to recognize his voice?
Yes.
Okay. And based on that familiarity, if I were to play you a clip from an audio of exhibit number 169, would you be able to recognize his voice?
If I hear it, yes.
Okay.
so for the record, we're going to go to page 10, line 167 of the transcript. It will be at 48 seconds. I'll stop it right there. Did you hear two voices in that clip?
Yes,
Was one softer and one more audible?
yes,
Okay. And are you familiar also with Eric Alvarado's voice?
yes.
How long had you known Eric Alvarado for?
Since his time of employment, I don't recall exactly how long. It was a shorter time period than Jose Soto.
Had you had multiple conversations with Eric Alvarado?
Yeah, I'd greet the team every single morning, all the employees, yes.
Okay. And can you tell the jury the identity of the individual whose voice was less audible in that clip?
The one that had a lower voice,
Yeah.
Eric Alvarado.
Okay. And can you tell the jury the identity of the individual who had a more clear and more audible voice?
Yes, that would be Jose Soto, Escalera Soto.
Okay, thank you. We're now going to show you yeah, now we're going to publish States 170, okay? Okay, I'm going to show you a video from August 21st of 2018. Okay, yeah.
It's just a blanket, Nancy.
Okay. Are you, can you take a look at those individuals in that one that's working?
Yes,
Okay. Do you recognize who the driver is?
yes.
What's his name?
Jose Soto Escalera.
And do you recognize who the passenger is?
Yes,
What's his name?
Eric Alvarado.
Okay, thank you. Yeah. We'll go to August 23rd of 2018. Video. Yep, and here we are looking at a video from August 23rd of 2018. Who is the driver
Jose Soto Escalera.
and who is the passenger?
Eric Alvarado.
And here we are looking at August 25th of 2018. Who is the passenger?
With the sunshine, do you mind if I walk up, please?
Sure.
Thank you.
That's a good question, Michelle.
What's the identity of the passenger?
The passenger is Eric Alvarado,
And the driver.
Jose Soto-Escalera.
When I worked at the hospital, I live in North Florida, but there's still I can't talk. There is still a substantial amount of Spanish-speaking people in North Florida too. Not as much as South Florida, but still. And I worked with some Spanish-speaking nurses, and I would have to go get them to translate for me a lot. But there was one nurse that I worked with. She was right out of school. She was very young, and she did not look Latina at all. And she was taking care of a kid, and the parents were bilingual, but they didn't know that she was. So they were talking about her in Spanish, saying about, oh, she was just a young kid. She didn't know what she was doing. She was a terrible nurse. They were going to ask for another one because they didn't like her. And she understood every single thing they said about her. And they were talking in Spanish thinking that she wasn't going to be able to understand them. And she came to me and she's like, you're not going to believe what just happened. I'm like, go tell the charge nurse. She'll assign you to a different kid, and you can give that kid to me. I'll take him. And she's like, no, that's fine. I'll keep going. I'm like, did you say anything to him? And she's like, no, I was just nice to him and asked him if they needed anything else. I'm like, oh, honey, I would have said something. I would not have let that gone. I would have had to say something. I would have been like, excuse me, I just understood everything you said about me. But I guess maybe that's why they were speaking in Spanish. Maybe they thought that nobody would understand them or nobody would try to figure out what they were saying. It's stupid, but maybe. I mean, it's a language. It's not a secret code. Yeah, they are dumb. This is true.
Okay, same question on the video from August the 27th of 2018. Who is the driver?
Jose Soto-Escalera,
And who is the passenger?
Eric Alvarado.
Okay. If we could return, we're going to do one more. Sir, thank you very much. That's all we have left.
Thank you.
Any questions from the defense?
No, Your Honor.
May Mr. Cavelli be released from his subpoena at this time?
Yes, sir. Any
Thank you, Mr. Cavelli. You're released from your subpoena. You're free to stay or leave as you wish.
Thank you very much, sir.
Thank you. And the state's next witness or item of evidence.
Your Honor, at this time, the people said for arrest.
Ladies and gentlemen of the jury, at this time, the state has rested its case. Let me ask you to step back into the jury room for a moment. Please do not discuss the case and leave your notes on your chairs, and we'll be with you momentarily.
Is it time for JOA?
All right, the jury has exited the courtroom at this time. The state has rested its case. Any motions from the defense?
questions from the defense.
Okay. And from the defense,
No?
no witnesses other than whether the defendant is going to testify? Do you need time to confer? Sure, confer with the defendant to make a decision whether he wishes to become a witness. I'll inquire of him in that regard, and then we'll go from there. But we'll go off the record, giving the attorneys a chance to speak with the defendant to make that very important decision.
Wow, I'm surprised no JOA. I mean, not that it would have been granted. They don't ever grant it. But
Case, unlike most
I still like to hear the arguments. Even though they don't ever grant them, it always interests me to hear the arguments. Judy.
the defendant regarding his decision to become a witness at this time. Mr. Soto-Escalera, you can be seated, but if you raise your right hand, the clerk will swear you just for a brief inquiry from me on that particular point.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Mr. Soto-Escalera, the decision whether to become a witness in the case, unlike most decisions in trial, is personal to you, meaning you receive the advice of counsel, but you make the decision up and above their advice. If there's a disagreement as to whether you should testify, you get to make that call, even if you disagree with your attorney. You have received their counsel. Are you first of all, do you understand the decision is personal to you?
Yes, sir.
Are you deciding to testify or not?
No, sir.
Not. Are you doing that of your own free will?
Yes, sir.
I will find that you're making the decision not to become a witness freely, knowingly, and voluntarily, and will proceed in that fashion. And therefore, let's discuss the plan. My suggestion is to release the jury till, when they come in, have the defense rest, release them till 1 o'clock. We'll do a quick charge conference and give you the remainder of the 2 hours to polish your closing arguments and proceed at 1 o'clock. Is that a good plan?
I think the parties might have agreed a different plan, Judge.
Okay. Well, I'm open. I'm open. I'm just, okay. I know we talked about finishing tomorrow too, which is possible. Is that what you had your eyes on?
Yes, sir, if that would be okay with the court. Yeah, Friday works better, if that's okay. We've had a long 3 weeks.
I'm open to that. Of course, the advantage if you do it this afternoon, I realize, I've done your jobs as well. So I realize, what goes into a closing argument. The advantage is, if there is a conviction, you get tomorrow off to prepare. There's that too. But either way, is that what you both agreed on?
Yes, sir.
Okay, that's fine with me. All right, so then I would bring in the jury, have the defense rest, and then tell them they're excused for the rest of the day. We'll do closing arguments tomorrow morning.
I do have a suggestion. Judge,
Sure.
and, you can deny it. What?
Rest tomorrow for you?
No. I don't mind resting now. I was just wondering if we could do the charge conference now and charge the jury today, and that way when we come back tomorrow, we could just go straight into closings and then they deliberate.
You want me to read the instructions to them before your closing arguments?
Yes, sir.
State agree?
Read all the jury instructions before?
Correct, that's the
Yes.
request.
You mean today or tomorrow?
Today.
Today.
That way we make good use of the time.
So then what we would do closing, and then you would remind them and say, I read you the law yesterday?
Yeah, I've never done that, but it's a standard practice with other judges. Nothing wrong with it.
And they're gonna get a copy of it anyways.
Exactly.
Yeah, probably.
I just think that'll give them something to ruminate
Saves
over
us time.
tonight.
I have no problem. It's time efficient for me.
Right.
And I've always wondered why there's not more requests to do that, because they'll know what the law is before you make your arguments, as opposed to the other way around.
Exactly.
Okay. And I'll tell them the attorneys have agreed with this procedure. I'm going to instruct you on the law, and then they're going to make their arguments tomorrow. Don't form any definite or fixed opinion. At this time, you haven't heard their arguments.
Correct.
Are you going to tell them in the instructions about their ability to review the testimony again? I think the only issue was the way it was said could be interpreted that they have to listen to the whole trial, and that that rule only applies to individual witnesses.
Well,
Yes, sir.
you have my name in that regard. Just took out, obviously, the defendant to become a witness. What I have remaining for your consideration, from my perspective, before we go back to the beginning, under weighing the evidence, can I take out, has the witness been convicted of a felony?
Yes, sir.
Because there's no such thing in this case. Okay.
Correct.
And how about, my default position would be to leave it in, but any pressure or threat been used against the witness that affected the truth of the witness's testimony? We could have had that in this case, but I don't think we is there any of that? Anybody want that?
No, sir.
State?
I couldn't quite hear, I'm sorry.
Has any pressure or threat been used against the witness that affected the truth of the witness's testimony?
Not
Both sides agree. I'm going to take that out. So now we have in that section 7 with the extras being received money, which there is, and making a consistent statement, which also is. And all right, so going to the top, any objections to the way I have it? You may, I don't know if you caught this, because the last version I sent you, I don't think I alerted you to this, but there was one section I added in, unborn child, where it should be. I don't know if you caught that, but it's there now, and it's proper in one of the unborn child instructions. I think it was actually on page, what should be page 5 for you, lesser included. That last sentence, the lesser included crimes of first-degree murder of an unborn child or second-degree murder of an unborn child and manslaughter of an unborn child. Before it said just second-degree murder or manslaughter, so I just added that in. It's a very slight tweak. You may, if you see that. But, so we have introduction, statements of charges, introduction to homicide, justifiable homicide, excusable homicide, first-degree murder as to count 1, count 2, first-degree murder of an unborn child, lesser included crimes, and then second-degree murder, lesser offense as to count 1, manslaughter as to count 1, second-degree murder of an unborn child as to count 2, manslaughter of an unborn child as to count 2, plead not guilty, reasonable doubt, weighing the evidence, defendant not testifying, defendant's statements, rules for deliberation, cautionary instruction.
Yeah, she's mad about the jury foreman and her TikToks. That's one of the reasons.
Verdict, single defendant, multiple counts. As to all of that, any objections or suggestions before I get to the part Mr. Cormier mentioned, which is, I'm going to get to that, what I have now. You can see what I have as far as, it's the second to last paragraph. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most, but not all, of the exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine an exhibit in evidence that was not sent back with you into the jury room, please let us know, and we will bring you into the courtroom to do so. That's my standard instruction. I don't touch the issue about rehearing testimony at this time. If they have a note, we do. And what I was alluding to when I spoke to them about that was the default position is to play the entire testimony of those two witnesses, which is the safest, more proper thing to do. I have had it sometimes, and the law does allow, if they specify to us one particular place, you could do that. But in this case, it's going to be extremely difficult. I'm not sure how they would do that unless they were going like section 3 or something like that, as Mr. Richardson was referring to it. You know, if they did that, perhaps there would be an agreement. But otherwise, it'd be the default position. And those portions are really not very long anyway. So
Yeah, he did.
my default position would be to do that, but it's not addressed in there. So do you want some time to look over what's there and see if you have any objections to it before I actually instruct the jury?
Yeah, he did yesterday.
2.
Page 2.
Count 2. In element 2, there's just a typo for the name of the defendant, actually, and also in element 1.
You're saying page 2. I have page 2 is excusable homicide.
So do I.
Oh, no, I'm sorry. I'm sorry, count 2, first degree murder of an unborn child.
So, yeah, it says Soto-Escalera. Soto-Escalera.
Oh,
And I think
that,
it's spelled
okay,
wrong in the-
gotcha.
Yeah, it's spelled wrong in number 1 as well.
It is spelled wrong in number 1?
Yes, it's
E-R-A.
E-R-A.
Oh, okay, gotcha.
And I think in the other count, you had his middle name.
Let me see, hold on.
Sometimes it has Tanya's middle name and sometimes it doesn't.
Her middle name or his?
His.
And hers, sometimes she's referred to as Tania Wise, sometimes she's referred to as Tanya Esther Wise.
Anyone have a problem if I just get rid of the middle names and we say Jose Soto-Escalera and Tanya Wise? Because middle names, like, what are we?
No
It's like a
objection.
wedding
No
invitation or something, you know?
No objection.
Okay, so I will go ahead and do that. Let me see, hold on. Let me go ahead and do that. As you're reading over the rest of them, just taking my time, it's without using control find, just going through it, so don't make any other.
We don't have any objections or reservations.
They look good? Okay.
Yes, sir.
How soon after Charlie Adelson was convicted was Wendy Adelson arrested? Answer my question.
State's still looking over the instructions, right? Okay.
I have no objection.
Okay, let me finalize
How
the
long after Charlie
issue
Adelson
about
was convicted was when
names.
Crap. How long after Charlie Adelson was convicted was Donna Adelson arrested? That doesn't answer my question. Dang it. How soon after Charlie Adelson was convicted was Donna Adelson arrested?
It appears Donna Adelson was arrested in late 2023 after authorities caught her trying to board a flight to Vietnam, and her son Charlie Adelson was convicted around the same time, receiving a life sentence in 2023. The exact timeline isn't clear, but it seems Donna's arrest followed Charlie's conviction closely, given both events occurred in 2023.
Okay. I Googled, and Google didn't help me. So then I meta'd. What do you call it when you ask Meta something? Is it meta'd?
The advantages of doing this too is if there are mistakes that are catching.
Anyway, I asked Meta. And it said Charlie was convicted in 2023 and Donna was arrested in 2023. So, I guess if when he's going to get arrested, it's going to be pretty soon. So, and the grand jury is supposed to meet this week. So, hopefully it'll be soon. But they better be watching Texas Airport. She lives in Texas now, right? And I think she had, at the very least, she knew about it. And at the very most, it was her idea. I don't think she actually did anything, though. But I still think that makes her just as guilty. And I'm not so sure. I mean, it may have been a joke, like a TV was cheaper than a hitman. But I don't think it was like a joke, just a joke. You know what I mean? It was a joke that had a meaning behind it. Can they put her on a no-fly list? Can the FBI put her on a no-fly list? Like if they want her to not be able to leave the country? I don't know. That's a good question, Nancy. I don't know.
Instructions orally, I'll correct them, and then I'll correct them in writing so that they get a perfect copy. It's actually better in that regard. So as I read along, does anyone want a hard copy of the instructions finalized?
Oh, man.
I would.
Okay, do that. What I'll do tomorrow too is, it's my normal practice in reading the instructions to explain the verdict form. I won't do that. I'll read them the verdict part, but I'll explain the verdict form to them after your arguments tomorrow before they go back, because it's normally, that's the purpose of that. You're about to go back and deliberate. Also, submitting case to jury, I should probably read that tomorrow. So I'll just stop at single defendant, multiple counts. Tomorrow, I'll reiterate the verdict, single defendant, multiple counts, in submitting case to the jury, explain the verdict form, and then send them back tomorrow. But at least I'll get the full instructions on the law at this time. Here's a copy for each side, hard copy. And let's bring out the jury and I'll instruct them. Do ask those who are here in the audience, you're free to remain, but you must remain during the whole instructions. I don't want people coming in and out of the courtroom while I'm instructing the jury on the law.
Have we watched a trial where the defendant case? I don't think I have. I don't think we've watched one together
We're doing that tomorrow.
where the defense didn't put on a case. I can't think of one.
Unless you just want to forego your closing arguments altogether. Yeah. Right. I think I'd urge you to do your closing argument.
Didn't she say she lived in Texas at her mom's trial?
All right, the jury is present. The state has rested its case at this time. Does the defense also rest its case at this time?
The defense rests, Judge.
Ladies and gentlemen of the jury, both sides have now rested their case. What we would normally do at this time is do the closing arguments, and then I would conclude the trial with the jury instructions and have you deliberate. We're going to depart from that and use an alternate procedure, which is perfectly fine and legal and perhaps better for this. What I'm going to do at this time is instruct you on the law as agreed upon by the lawyers, and then they're going to make their closing arguments to you tomorrow morning, after which you'll begin to deliberate on the case. The advantage of this is you'll have heard the law already as an advantage to you understanding their arguments to put it into context. But please remember something I instructed you on throughout the trial, which is do not form a definite or fixed opinion on the merits of the case until you've heard all of the evidence, the arguments by the attorneys, and the law as I instruct you. And it was stated in that sequence because that's normally the sequence. So you're going to hear the law, but don't form any definite or fixed opinion until you've heard the attorney's arguments tomorrow. And of course, until the time I send you back into the jury room, don't discuss the case with anyone, including your fellow jurors. I suppose what I'm saying is the fact that I'm going to instruct you on the law now is not an invitation to start your deliberations, which are actually mentioned in the instructions, that you don't start your deliberations until tomorrow after the attorneys make their final arguments to you. Also, I'm going to be reading the instructions to you. Tomorrow, after the arguments are made, these instructions will go back with you into the jury room, and I'll have a copy for each of you individually for you to refer to should you need further reference to the instructions during your deliberations. And members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Jose Soto-Escalera, the defendant in this case, has been accused of the following crimes. Count 1, first-degree murder with a weapon. Count 2, first-degree murder of an unborn child. Introduction to homicide. Jose Soto-Escalera is accused of first-degree murder in counts 1 and 2. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Tania Wise and her unborn child were killed by Jose Soto-Escalera, you will then consider the circumstances surrounding the killing in deciding if the killings were first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. I now instruct you on the circumstances that must be proved before Jose Soto-Escalera may be found guilty of first-degree murder with a weapon, first-degree murder of an unborn child, or any lesser included crime.
Too.
Count 1, first-degree murder.
I believe that
To
too.
prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Tania Wise is dead. 2, the death was caused by the criminal act of Jose Soto-Escalera. And 3, there was a premeditated killing of Tania Wise. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Jose Soto-Escalera did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jose Soto-Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tania Wise. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted, you should not find him guilty of first-degree premeditated murder. If you find that Jose Soto-Escalera committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of first-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed first-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of first-degree murder. Count 2, first-born child. To prove the crime of first-degree murder of an unborn child, the state must prove the following two elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tania Wise by killing Tania Wise, and 2, Jose Soto-Escalera's killing of Tania Wise was first-degree murder, as I have instructed you in count 1. Unborn child means a member of the species Homo sapiens at any stage of development who is carried in the womb. When there are lesser included crimes, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which Jose Soto-Escalera is accused, there may be evidence that the defendant committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes of first-degree murder with a weapon are second-degree murder and manslaughter. The lesser included crimes of first-degree murder of an unborn child are second-degree murder of an unborn child and manslaughter of an unborn child. Second-degree murder, a lesser included offense as to count 1. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tania Wise is dead. 2, the death was caused by the criminal act of Jose Soto-Escalera. And 3, there was an unlawful killing of Tania Wise by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Jose Soto-Escalera did not have a depraved mind without regard for human life, because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life, because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jose Soto-Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tania Wise. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of second-degree murder. If you find that Jose Soto-Escalera committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of second-degree murder. Manslaughter, a lesser included offense as to count 1. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Tania Wise is dead. And 2, Jose Soto-Escalera intentionally committed an act or acts that caused the death of Tania Wise. Every person has a duty to act reasonably toward others. If there is a violation to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Jose Soto-Escalera committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of manslaughter with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of manslaughter. Second-degree murder of an unborn child, a lesser included offense as to count 2. To prove the crime of second-degree murder of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tania Wise by killing Tania Wise. And 2, Jose Soto-Escalera's killing of Tania Wise was second-degree murder, as I've instructed you in count 1. Manslaughter of an unborn child, also a lesser included offense as to count 2. To prove the crime of manslaughter of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tania Wise. Killing of Tania Wise was manslaughter, as I have instructed you in count 1. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court. Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not, let me start over. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. And counsel, I'm striking that next sentence in this particular case. Whatever verdict you render, start over with that sentence. Little tongue twisters here. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proved beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course the verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And tomorrow, after the arguments, I will show you the verdict form and explain it to you before I send it back with you for your use. Single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. The last instruction is submitting the case to the jury, which I'm going to do with you tomorrow. So after the arguments are concluded, I'm going to reread to you the few of the last pages here before I submit the case to you. That concludes the instructions at this time. Tomorrow we will reconvene at 8:45 in the morning, just as we did today. Remember, I cannot overly emphasize, you have not heard the arguments of the attorneys. Don't form any definite or fixed opinion about the merits of this case at this time. The same rules that govern your conduct remain in effect. Of course, in abundance of caution, please remember, avoid any exposure to any extrajudicial information. Don't talk to anyone. Don't do any research about the case or the people or the issues involved in the case. To be sure, you can find your consideration of this case only to the proper evidence and nothing else. Avoid all of the media coverage of this case. With that, enjoy the rest of your day and your evening, and we'll see you tomorrow morning. Please leave your notes on your chairs. Jury has exited. Before we break, let's take a look at the verdict form as well, just to be sure there's no objections to that. Oh yeah, I wanted to take out the form as to count two. The state had put in a weapon, which doesn't apply to count 2, so I'm going to take that out. You remember that? Okay. And I also put unborn child in the language as to count 2, which fits the charge. It just said first degree murder. It didn't say unborn child. So I have that as the count 2. And it is still September. So that's correct on the verdict form, right? And so right now the verdict form says we jury find Jose Antonio. I'll get rid of the Antonio.
That's all right, yes.
Do that also on the top there. Verdict form. We, the jury, find Jose Soto-Escalera as to count 1, select only 1, guilty of first-degree murder as charged in the indictment, guilty of second-degree murder as a lesser-included offense, guilty of manslaughter as a lesser-included offense, or not guilty. If you find the defendant guilty as charged or guilty of any of the above, there's an error there, above lesser offenses. I'm adding a word there. You must next determine if any of the following has been proved beyond a reasonable doubt. Check yes if proved beyond a reasonable doubt. Check no if not proved beyond a reasonable doubt. During the commission of the offense, the defendant did carry, display, use, threaten to use a weapon, or attempt to use any weapon. Yes or no. Count 2, select only 1. Guilty of first-degree murder of an unborn child as charged in the indictment. Guilty of second-degree murder of an unborn child, a lesser-included offense. Guilty of manslaughter of an unborn child, a lesser-included offense. Not guilty. So say we all. This blank day of September 2025, 4-person. So that looks good. I'll print out a few copies of that to give to you all and for myself here. And anything else before we break from the case? From the state?
And my only request for tomorrow would be to have it maybe a 5 or 10 minute bathroom break after Vince finishes the
After the defense part? Well, that reminds me of another issue. So what we should do for the bailiffs, take the lunch order of the jury as soon as possible, because they're going to be here for lunchtime for sure. Are we still using roots or whatever? Oh, there you go. That's less sensitive than the other like some kind of sprouts and something. So that's good. Let's take their order so that it's there and we get the lunch, because it's going to be right about lunchtime that we're going to submit the case to them. And as far as the bathroom break, that's perfectly fine. In fact, Miss Minton, if you want one after they get finished too, I'm just kind of giving you a wink and a nod, and we'll do that as well. All right, and if there's nothing else, how about this? Maybe this is a good time to check over the evidence. That we're absolutely sure there's nothing going back that shouldn't.
They've already locked it up.
Oh, okay.
Well, I mean, I'm open it back over, you can look in the clock, because the clock is really, and it's not gonna take that long. I pull it.
There's not that much.
Just to avoid calamity, the items that are not fully admissible, that we've done those, I forget, 1/6, exactly,
170, 183.
which are not going back to the jury. But if they did, is there any request for a laptop to go back to view other stuff? There's not, so we're kind of doubly safe. Even if it goes back accidentally, they can't view it anyway, because they don't have electronic.
Well,
no,
I take that back. The defendant's interview.
And
The defendant's interview.
surveillance videos are going back there.
Right, so we
they
need to
will
be
have a
extra
laptop.
cautious to make sure that those don't go back. And the other item that's not, just make sure the other items that are not into evidence do not go back into the jury room, because there's several that were marked that are not into evidence, right?
Yeah.
I'm gonna strike that. You all caught that? That was good, Johnny, on the spot. The sentence that I said was, I decide the sentence. Well, no, well, Judge, why do we spend 2 weeks in death qualification?
We're not supposed to have it in there.
Yeah, right. That was a good catch by me. I'll strike that and reprint the instructions for myself and for the jury. All right, and then we'll be adjourned until tomorrow morning at 8:45. Thank you.
Okay, guys. That's all for today. Man, these early days are killing me. Not that I'm making any money yet, though. Because I don't have enough subscribers. I had 7 7:17 yesterday. I'm down at 7:16 today. So I took somebody off apparently. I don't care. I really don't care. Oh well. Okay, guys. Oh, that's cool, Nichelle. I hate to cook. I avoid it at all. When at all possible. My husband likes frozen dinners now, so I'm happy. Okay, I will see you guys tomorrow. Have a great afternoon and evening. And remember, be kind to people, love your family, and Jesus loves you, and so do I. Bye, guys. I will see you at 8 in the morning, bright and early, and then we will work on Betty's trial, and then at 9:30 we will jump over here and listen to closing arguments. So I will see you tomorrow. Bye.